Good afternoon, everyone. I'm Russ Feingold, President of the American Constitution Society. And on behalf of ACS, I'd like to welcome you to today's briefing call, a conversation on the role of State Attorney General in police oversight and accountability. The events of the past month have brought renewed attention to concerns about policing in America. The killings of George Floyd, Breonna Taylor, and Rayshard Brooks by police officers have once again focused our attention on police violence against Black people. The COVID-19 pandemic has further highlighted the differences in the way communities of color are policed, sometimes with violence for violating social distancing and stay-at-home orders. And police use of tear gas, pepper spray, batons, and rubber bullets on people protesting police brutality has amplified demands for changes to police tactics to ensure that officers protect and defend the constitutional rights of the people they serve. We already see local, state, and federal officials moving to address police brutality and racism in policing. State and local officials across the country have moved to ban the use of chokeholds, increase transparency of police misconduct, and give greater authority and more tools to state attorneys general to address police violence. While their authority varies from state to state, state attorneys general have worked in a variety of ways to address problems in policing their states. As states' chief legal officers, state attorneys general swear to uphold the U.S. and state constitutions and to enforce federal and state laws. The heart of a state attorney general's mission is to serve the public interest. With broad jurisdiction and independence to act, state attorneys generals play a crucial role in upholding the rule of law and protecting the rights, health, and safety of their state's residents. Recognizing the unique role that state attorney generals play in our system of government, I'm proud to say that ACS established the State Attorney General's Project in 2017 to develop and disseminate legal resources and host programming and events examining the actions of state attorneys general and the emerging legal and policy issues they face. Today, ACS and the State AG Project are pleased to welcome two state attorneys general, Grewal of New Jersey and Kwame Raoul of Illinois, for a conversation about their role in police oversight and accountability. So now I'd like to turn it over to Valerie Nannery, the Director of Network Advancing, who will introduce our speakers and moderate today's conversation. Valerie?
Thanks very much, Russ. Before I introduce today's speakers, I want to take a minute to cover a few housekeeping matters. Today's call is being recorded, and the recording will be available after the call on ACS's website at www.acslaw.org. Second, we will be taking some questions from listeners and viewers toward the end of our conversation. If you'd like to ask a question, you can type it into the Q&A box at the bottom of your screen at any time. We will try to get to as many questions as possible. Finally, 1 hour of California CLE credit is available for this call. Please email us with a conversation on the role of state attorneys general in police oversight and accountability in the subject line at info@acslaw.org to receive your certificate. If you are seeking CLE credit in a jurisdiction other than California, please consult the rules of that state's CLE board to see if it provides for reciprocity with California. CLE materials can be found on the event page of the ACS website and will be shared with all participants in a follow-up email. Now on to today's distinguished guests. Grewal serves as New Jersey's 61st Attorney General. Nominated by New Jersey Governor Phil Murphy in 2017 and confirmed by the New Jersey Senate in January 2018, Attorney General Grewal has focused his attention on protecting the interests of New Jersey residents by expanding affirmative litigation, strengthening police community relations, reducing violent crime, and fighting the opioid epidemic. Before becoming the Chief Law Enforcement Officer and Chief Legal Officer for the state of New Jersey, Attorney General Grewal served as Bergen County prosecutor, an assistant United States attorney in the criminal division of both the U.S. Attorney's Office for the District of New Jersey and the U.S. Attorney's Office for the Eastern District of New York, and also worked in private practice. Attorney General Grewal graduated from the Georgetown University School of Foreign Service, and he obtained his law degree from the College of William and Mary Marshall Wythe School of Law. Kwame Raoul has served as the 42nd Attorney General of Illinois since 2019. In 2004, he was appointed to serve as the state senator representing the 13th Legislative District, where he was subsequently re-elected and represented the district for 14 years. As a legislator and an attorney, Attorney General Grewal has been dedicated to working towards criminal legal reform in Illinois. In addition to spearheading the abolition of the death penalty as a state senator, he sponsored numerous diversion and second chance programs for nonviolent offenders and expedited the process of record expungement for juveniles. He pushed through landmark law enforcement reform, including standards for police officer-worn body cameras and a statewide database of officers under investigation. He began his legal career as a prosecutor in the Cook County State's Attorney's Office and subsequently served as a senior staff attorney for the City Colleges of Chicago. Attorney General Raoul has also been a partner at 2 national law firms. Attorney General Raoul earned his undergraduate degree from DePaul University and his JD from Chicago-Kent College of Law. Thank you both for joining us today for this important and timely conversation. I'd like to start with talking about the U.S. Department of Justice. Prior to 2017, US DOJ investigated police departments across the country and negotiated consent decrees to ensure that the police respect the civil and constitutional rights of people in their jurisdictions. But in 2017, US DOJ not only stopped such investigations, it declined to follow through on completed investigations and even attempted to undo its consent decree with Baltimore and its police department. Attorney General Raoul, your office stepped in when US DOJ abdicated its authority after concluding its investigation into unconstitutional policing by the Chicago Police Department. Can you explain how your office filled the void left by US DOJ?
Yes, certainly. First, I have to give credit to my predecessor, General Lisa Madigan, who actually contacted DOJ requesting their initial patterns and practice investigation on the heels of the revelation of a shooting of a young man by the name of Laquan McDonald. Under the Obama administration's DOJ, Loretta Lynch initiated that investigation, leading to a 160-page report, which was issued in January of 2017, right before passing the baton to the Trump administration and Attorney General Sessions. Our office, once Jeff Sessions indicated that he was not going to go forth with the responsibility given to the Department of Justice, stepped in the 1983 action under Parens Patriae theory and filed a lawsuit to take over and eventually negotiated a consent decree based on that lawsuit, information gathered from law enforcement experts from throughout the country, as well as a DOJ report issued by Attorney General Lynch.
So that consent decree was approved by the court in January 2019. What is your assessment of whether the Chicago Police Department is meeting the requirements of the consent decree?
Yeah, so ironically, I came into office in January of 2019, and 2 months afterwards, or a month and a half afterwards, in March of 2019, began the implementation phase of the consent decree. unfortunately, at this stage, and we have run into problems connected to COVID-19 in terms of compliance. But prior to COVID-19 and its effects, the Chicago Police Department, the City of Chicago, and the COPA, the Independent Investigation Arm, was falling short of compliance with the consent decree, missing 70% of the associated deadlines for the plans to address the problems identified by the DOJ investigation and negotiated by way of the consent decree. And so we're at a stage now where the city is putting forth a plan to catch up. And we have a court monitor and a special master in play to help mediate and to keep the city accountable, as well as our office and other parties who are party to the suit as adversaries to the city and the Chicago Police Department to help keep them accountable.
Well, Attorney General Raoul, I'll stick with you for a minute. You and New York Attorney General Letitia James recently sent a letter to congressional leaders urging them to give states' attorneys general statutory authority under federal law to investigate and resolve patterns or practices of unconstitutional policing. 18 state attorneys general, including Attorney General Grewal, signed on to this letter. Can you explain what you asked for and why this legislative change is important and necessary?
Well, given, as we mentioned before, and as you mentioned in your introduction, that then Attorney General Sessions and now Attorney General Barr has clearly given the signal that that the Department of Justice is not going to exercise the powers given to them by Congress by way of the 1994 crime bill to initiate these patterns and practice investigations to help lead to constitutional policing in local police departments. And so given that, the role of the state attorney general gets lifted up. And while we intervened by way of a 1983 suit under Perens Patriot theory, that approach has not been challenged or litigated in the various circuits. And so what we are seeking is the same specific authority given to the Department of Justice by way of the 1994 crime bill given to state attorneys general. I'm not naive about the process between the chambers and in Congress. Fortunately, Congress has acted and passed a bill that includes our request. It initially did not have that element in the initial draft of the bill, and we were able to collectively have conversations with Speaker Pelosi and Chairman Nadler and others engaged in the process to get the language we wanted put in. Senators Harris and Booker, I believe, introduced a bill in the Senate with similar language. However, the bill introduced by Senator Scott doesn't come close to having that language or other necessary language to lead to appropriate reforms. So I think consistent with that or concurrent with that, we have to all, within our individual jurisdictions, seek to go to our state houses and make certain that we get explicit powers by way of what can occur in state courts. However, it is preferable for us to have the avenue to federal courts for enforcement of these consent decrees.
Attorney General Grewal, you signed on to the letter to Congress, but your authority over law enforcement in New Jersey is very different than that of most state attorneys general. Would you briefly describe your authority over policing in the state of New Jersey and explain why you joined General Raoul's request for additional authority under federal law?
Certainly. Let me just start by thanking ACS for putting together this forum, and it's an honor and a privilege to join Senator Feingold and AG Raoul and you, Valerie, for this conversation. The legislation that AG Raoul is leading the charge on would essentially give my fellow AGs some of the same broad authority that the New Jersey AG has had for some period of time. We've seen here in New Jersey how that authority leads to reform, can lead to increased accountability, and can have positive effects. And so that's why I signed on to the letter, so my colleagues can get that same type of authority. And so they could perhaps look to New Jersey as a model of how to use that authority. The way we're structured here in New Jersey is that the Attorney General is the chief law enforcement officer in the state. We have 21 counties. I oversee all 21 county prosecutors who are the chief law enforcement officers in their county. By extension, I have supervisory authority over all 36,000 law enforcement officers in the state, and I have supervisory authority over the 533 police departments in the state. The New Jersey State Police is within my office, so I have direct oversight over them and our state's Division of Criminal Justice. What that means in practical terms is that I have broad authority to supersede individual police departments or even county prosecutors' offices if there is indication of a pattern in practice, for example, of unconstitutional conduct, or if there are other problems within a particular police department. And I also have broad authority to issue what are called Attorney General directives. These are binding policy documents that control everything from training, how cases are investigated or prosecuted, different aspects of policing. To give you a couple of examples on the ability to supersede. As you mentioned in the introduction, prior to becoming Attorney General, I was a county prosecutor. Very early on in my tenure as a county prosecutor, I was confronted with the police department in my county where the police chief had issued an email in this day and age to his law enforcement officers to stop suspicious black people who came into their town. That led me to launch a pretty robust investigation, but the first step was that I superseded that police department, installed my own monitor in there, put in somebody to act as the chief, did a thorough up and down of that department to make sure that no one was acting on that chief's directive. And we looked at 5 years of data to make sure they had a clean bill of health. Similarly, now as Attorney General, I've had indication that some departments where some statements have been made by chiefs and others, we've gone in and taken over functions of those police departments until we were satisfied that there was nothing untoward happening. And similarly, with the Attorney General's directives, while I have the ability to issue these directives on my own, what I do is I engage in a process. I listen to stakeholders, from law enforcement stakeholders to civil rights stakeholders to a whole array of different groups, because I think through that type of collaboration, I could create better law enforcement policy with community input and with stakeholder input. So we've used that authority to really push forward some meaningful change over the last 2.5 years. So it really sets New Jersey apart, and it's why I hope my fellow AGs can get some of these types of authorities.
Well, late last year, Attorney General Grewal, you announced your Excellence in Policing initiative, a package of 8 policy initiatives intended to promote a culture of professionalism, accountability, and transparency in New Jersey law enforcement. Can you briefly describe how your initiative aims to accomplish these 3 goals?
Yeah, sure. We launched that in December of 2019. That's when we issued a number of these AG directives, which I described for you earlier, the authority that I have. But that doesn't mean that we just came up with them in December of 2019. We spent the better part of 1.5 years just listening, because the first thing you need to do is just listen. And so I think one of the things that I'm most proud of as AG is an initiative that we call 2121, 21 counties, 21st century policing. We launched that in January of 2018. We asked all of our county prosecutors to have quarterly meetings in their counties where the community was, not at the prosecutor's office, not at state government offices, but go to the church basements, go to the school gymnasiums, go to the community centers and hear from the community. So we had well over 100 of these meetings the first year, even more in 2019. And what we saw was that there were huge divides still in this state, despite our progressive policies, between law enforcement and community, divides filled with mistrust. And we felt that we could bridge them by making sure that the professionalism, the transparency, the accountability, the hallmarks of our best police departments in this state were codified in these directives and pushed out to all 21 counties. So how did we do that? When it came to professionalism, we said that we were going to really just do a fresh deep dive into how we train our law enforcement officers, throw away the old playbooks and come up with a new playbook to reflect what it means to be a police officer today. And so that work is underway. We started that well before the events of last month. We started that in December of 2019. We wanted to also implement what we called early warning systems. So we don't have that problem officer who on his 19th incident does something tragic to a resident in one of our communities. So these early warning systems are now in place that there are whole categories. If red flags are tripped, a chief has to intercede, has to come up with a corrective plan, and our county prosecutors have to oversee that process. So we don't want that problem officer to engage in unprofessional and, unfortunately, in some cases, as we've seen, criminal and tragic conduct. We also push forward, as part of our professionalism, better training, implicit bias training. All of our state troopers are now trained on implicit bias, as are all of our state's prosecutors. Because it's okay to demand accountability from law enforcement, but let's not lose sight of the fact that it's our prosecutors who are arguing sentences, who are negotiating guilty pleas, who are indicting cases. So they too should be free of their subconscious biases. So those are just some examples on the professionalism side. On the accountability side, we put in place in December of 2019 a 10-step protocol on how we would conduct at the Attorney General's office independent investigations of officer-involved shootings that resulted in fatalities or in-custody deaths. Again, we realize that these are the most significant investigations that we can conduct as law enforcement officers, and we need a robust, independent process to do that. So we did that in December of 2019 for increased accountability. We also said we were going to start looking at police licensing in December of 2019. And that process has sort of moved on, and we've come to a conclusion there. And we also talked about more robust internal affairs guidelines on that accountability piece. And then just briefly on transparency, we decided very early on, because as AG Raoul mentioned, the Laquan McDonald case, what happens when there is no transparency? We saw that early on, and we said, you know what? If we have footage, body cam footage, MVR footage, any other type of footage, once we've completed our initial investigation, we will make that footage public and available to the public, because we don't want to sit on that and breed more mistrust. And so that's something that was part of excellence in policing as well. In addition, revamping our state's use of force policies and creating a state use of force database to collect data and make that publicly available as well. So just some of the examples of the policies, how we hit on the professionalism, transparency, and accountability piece. But it's a continuing process, and we continue to build on it.
That is a very comprehensive set of initiatives, and we will turn back to a couple of those points later on in our conversation. But I wanted to ask you about a recent letter that you sent to law enforcement chief executives saying that your 6-month-old internal affairs directive did not go far enough, and that more is required to promote trust, transparency, and accountability. What didn't your initial directive do, and what changes are you directing now?
Sure. Clearly, the events, as was stated in the introduction, as we all appreciate now, even more so than maybe even in December when I launched Excellence in Policing, is that there is clearly a larger crisis in confidence in law enforcement than perhaps I even imagined. And so what we had done in Excellence in Policing, we said, we're going to revamp our internal affairs guidelines. And I didn't mention that in my prior answer, but that was a piece of it. And we were going to put out, each police department in our state would put out there a summary, like our state police has been doing for 20 years, of major discipline that was given out by every department. And by the end of the year, that would be on every police department's website. The problem was that it was anonymous. It didn't contain the information of the officer's name. Our state police would put on their website, member received 500 days discipline for XYZ infraction. That's huge. That's major discipline. And we had a case in the Supreme Court, in our state Supreme Court, where we were fighting the release for years, prior to me coming here and continuing through my administration, releasing the name of a state trooper who was terminated for racially offensive and criminal conduct. And so in the wake of events that transpired in Minneapolis, in the wake of protests, I felt that we had to shine a light on those few officers who don't do their jobs well, because we're no longer going to protect the few to the detriment of the many, I said. And so now what we are going to do, and July 15th, I'm going to do it with respect to the state police, but by the end of the year, every department moving forward for cases of major discipline, if someone's been fired, demoted, we'll have to put that summary information to include the officer's name. But what I'm doing in the case of the state police is I'm going back 20 years. And what I'm doing with our Division of Criminal Justice, their detectives, and our Juvenile Justice Commission, which is within my office, is I'm going back 20 years. And we're going to put it out there because we want to be transparent. At the end of the day, you'll see it's a small percentage. But here's the thing. This is a no-brainer to me, and yet the unions are fighting me tooth and nail. And we had a status conference this morning with 3 pending lawsuits where literally we're fighting for 0.5% of the state police, 0.5% who fall into this category to the detriment of the 99.5. So I'm hopeful that they will see the benefit to being more transparent and more accountable in this particular moment, because that's what this moment requires of us.
We will definitely keep our eye on that litigation as it goes forward on your bold initiative. I want to turn back to something you mentioned, Attorney General Grewal. Both of you have discussed the lack of licensing of police officers in your states. I'm going to give the first question to Attorney General Raoul. Can you explain what licensing of police officers would entail and why it is important?
Yes, certainly. So currently we have a certification system within our state, and it's deficient on several levels in terms of uniformity in training and things of that nature. But the area that I think is most deficient is what happens in the instance of misconduct. So you take a lawyer, for example. We in Illinois have the Attorney Registration Disciplinary Commission. So notwithstanding what a firm or other employer may do in its employment process, a lawyer that engages in conduct unbecoming of a member of the bar can lose their license because of such misconduct. The same does not exist for those who carry and are able to use deadly force. And so the decertification process under our current certification system only allows for removal of certification upon the conviction of certain felonies. And so you have an officer like Jason Van Dyke, who was a shooter in the Laquan McDonald case, or Derek Chauvin, who was up in Minnesota, who was a shooter in the George Floyd case, that had a long history of complaints of misconduct, well-founded complaints of misconduct, yet there was an inefficient disciplinary process, inefficient in terms of being able to remove that officer from their duties prior to they're doing the harm that they cause. And this is something that I started to discuss in 2015 when I was a legislator and passed the law enforcement reform package that we passed then. And there was buy-in from those who head up law enforcement departments, the police chiefs, the sheriffs. However, as Attorney General Grewal mentioned, there was opposition from the Fraternal Order of Police, and we couldn't let the perfect be the enemy of the good, and so we passed a package that fell short of achieving that licensing, but we want to revisit that now. I have convened a chiefs of police, sheriff, our training board, our state training board, and some legislators to begin to have conversations around creating a licensing system in Illinois.
Attorney General Grewal, as you mentioned, you asked the Police Training Commission in your state to prepare a report. It was due June 1st of this year to evaluate whether to adopt a professional licensure regime for New Jersey police officers. Can you tell us what the report found and what you're recommending?
Sure. The report found that New Jersey is one of 6 states that doesn't have a robust licensing system. And while we might be fairly, on the front end of a lot of other areas when it comes to policing, this is one area where we lag behind. And so the report recommended that New Jersey move towards a police licensing system where we set certain baseline levels of professionalism that we expect from our law enforcement officers, that we develop a protocol for what types of events would trigger the loss of a license, what that framework would look like. And so those are the next steps. But as a first step, we had a meeting of our police training commission, of which I'm the chair. And so I voted in favor of that recommendation to take that next step to build out this licensing system. And it was a unanimous vote. And so while we might have some issues with the unions on certain reforms, on this one, they had 2 representatives on the Police Training Commission, and they voted in favor of licensing, which is a bold step in New Jersey because we've tried to get here before. Right now, perhaps given the moment, everyone's saw eye to eye on this issue. And so over the next number of months, we'll be building out what that system looks like. And I'll just give you an example of why we need this. Because just last month, in my state, I had a police officer, because we don't have licensing, who went from department to 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 department. That's not a technical glitch on Zoom. That's 9 departments. 9 departments at the age of 31. In his 9th department, in this current climate, dealing with 2 young African-American males who were sitting on their front porch steps, who he accused of loitering. He pepper sprayed them, unprovoked. Nothing that these young gentlemen did warranted that type of response. He was arrested by our Camden County prosecutor for assault, and he will be prosecuted on those charges. But he was able to escape his internal affairs history, his disciplinary history, because we don't have that licensing system. So I could plug holes through policies that require chief now to look into prior IA history before hiring somebody. But we need that licensing so people are not able to run away from this type of history and conduct. And so we could have some more accountability. And I think that case is a perfect example for why licensing is needed and what it could prevent if we had a robust licensing system in our state.
Wow, I did not know that only 6 states don't license police officers. But moving back to something else you mentioned earlier in your brief description of the Excellence in Policing initiative, and something that Attorney General Raoul has also advocated for, is better data about policing, especially data about the use of force. What data, and this is sort of open to both of you, what data do you need and from whom and why? What will you do with the data?
So, with our use of force policy, for example, given that ability that I talked about earlier to have uniform police policy and procedures through our AG directive authority, one of the directives we put forward was to create this use of force portal. As a first step, though, we wanted uniformity in what that use of force reporting looked like, because we wanted to be able to see how Department A compared to Department B in the same county or in the same area. Was the use of force higher in Department A based on number of incidents? What were the demographics of the individuals involved? Were departments or officers using force at a higher rate against Black and brown communities? So while we did a good job in the state collecting that information on paper records, and while it was required by my predecessors to send that information to the Attorney General's office, we never did a meaningful review of that information until a newspaper in New Jersey requested 5 years of data through Open Public Record Act requests, and then analyzed it and told us what the patterns were. But even then, it wasn't apples to apples. So what we've done, for example, in use of force now, is we had a pilot in 6 towns where we have a uniform portal. The information we're requiring, everything from weather, type of force used, demographics, charges, what was the ultimate charge. And so we looked at it and it was working. And so I announced last month that we were going to now go statewide with that portal in July. And I think that's going to help us both from an accountability perspective and also from a training perspective. If we can get in there early and give certain departments better training, if they are using force at a higher rate, or stop a problem officer early if we're able to see patterns emerge through this data. So that's just one example of where we could use the tools that we have now to collect data to inform our policy and our accountability efforts, and to be transparent, to share a portion of this publicly too.
Attorney General Raoul, I turn that same question to you.
Yeah, and I'm going to be a little bit of a broken record. I agree with General Grewal. I think, data on race, age, location of occurrence, injury, extent of injury, this type of information can be helpful in assessing, both at a statewide level as well as at a local level, whether there are patterns and practices. It should not take the type of patterns and practice investigation that the Chicago Police Department has undergone to begin to examine whether or not there are any systemic problems in any of the police departments throughout the state. So while I am asking for the authority as AG to be able to engage in patterns and practice investigation if there's evidence of unconstitutional policing, I think we can engage in reform by way of collecting data without having to pull the trigger on a patterns and practice investigation. We have, for a number of years, then Senator Obama, and then subsequently I amended a bill on traffic stops, and we expanded it to pedestrian stops. And that data that we collect with regards to those stops are able to inform policy, both at the statewide as well as the local level.
Turning back to Attorney General Grewal, in addition to collecting data about the use of force, you announced earlier this month, and you mentioned earlier in this conversation, that your office will be updating New Jersey's use of force policy for the first time in 2 decades. Can you tell us a little bit more about the process you're using to update the policy and when we can expect a new policy to be in place?
Sure. As you mentioned, the policy hasn't been updated since June of 2000. And we had talked internally about doing this for some time now, but obviously recent events have sped up this process. And we need a policy that reflects who we are as a state today, what our values are, what policing looks like, what police interactions look like in this state. And so I had indicated that we would get this done by the end of this year. My hope is that we'll get it done much sooner than that. But I think, again, going back to some of the things that I said earlier, we need robust community input here. That is the process that I've used with other AG directives. And again, I could issue those with a signature. That gives me some more freedom than some of my colleagues, that we don't have to wait for legislation. We could just do what we think is right in that moment. The danger, of course, is that the next AG comes and perhaps can undo that. But through a robust process, through robust engagement, I think we can get to a policy that is really a model for the rest of the country. So what we will be doing is hosting community listening sessions in all 21 of our counties. We kicked off that listening session tour online last week. We had, I think, well over 500 or 600 people participate. We had over 100 questions, as you're probably trying to monitor in your question pane, that we didn't even get to. So we'll have another session, like the one we did last week, just to give folks a background of the areas that we're looking at, where we want to get input, what we are looking to change, where we are looking to go, what some model policies are, like 8 Can't Wait, or what the IACP, the International Association of Chiefs of Police, have put out, what some of our departments have done in this state. Camden, New Jersey is pretty forward-leaning when it comes to policing policy. The former Chief Scott Thompson there has a great policy. So those are some of the things we're doing as far as listening sessions. And then we also set up an online portal where people can go and submit their thoughts. And we want to hear from everybody. We want to hear from civil rights leaders, religious leaders. We want to hear from cops. We want to hear from the general public. We want to get as much input as we can. And that website, that portal is nj.gov/OAG/force. And if people are interested, they can go see our current policies, some other policies, as well as the areas where we want to look at. Pursuits, situational use of force, proportionality, specific methods and techniques, high-speed pursuits. Everything is on the table, and I think we have an opportunity here to really build a model policy, something that other folks can really look to and adopt as something that is best in class. And the difference between other states is that once this is done, it'll apply to all 533 police departments. It's not police department A does one thing and B does another or C does another. And so that's a process that's underway. Having said that, we didn't wait for that process to send out an explicit directive early on in June that chokeholds are banned techniques in the state unless deadly force is needed in that situation. That's something we did fairly quickly through that authority that I talked about earlier.
Thank you, Attorney General Grewal. Before I turn to some of the questions that have been coming in, as you mentioned, there are quite a few. There has been a lot of discussion about the problems presented by sending armed police officers to answer a call about a person suffering from an acute mental crisis or other mental health issues. Attorney General Grewal, how do you respond to these concerns?
So, this is a really a conversation that can take an hour on all the issues that surround it, from, the defunding debate to, we should not have police officers doing mental health calls or responding to people with substance abuse disorder. The reality is, and if you talk to a cop who graduated the academy 25 years ago, I don't think they ever signed up to be a mental health counselor or a crisis counselor or a marriage counselor or a drug counselor. That is just a function they serve now because they are that last safety net. We have broken systems when it comes to mental health, to addiction treatment, to the educational system, to the health system. And at the end, it's our officers who are left dealing with much of this. So, when we talk about defunding or those types of issues and funding instead the mental health system, my response to that is we need to be smartly funding the police. They're dealing with this issue now. Yeah, fix all those other systems, but give me the money that I need to train officers in this state on de-escalation, on crisis intervention team training, on other techniques that they can employ when they deal with the person in a mental health crisis, so they can resolve that interaction in a peaceful manner, in a nonviolent manner, using other techniques. So that's what we're doing in my state. We're piloting crisis intervention team training across our state in our major cities, at our state house with our troopers who guard the state house. So when they do interact with somebody who's going through a mental health crisis, they could recognize it and they could try to resolve it without using force through additional techniques.
Attorney General Raoul, I pose the same question to you.
Yeah, so while I may not fully embrace the nomenclature of either abolish the police or defund the police, if we get a chance to look under the hood of what those terms are meant to convey by those who advocate for them, this notion of making certain that police are not assigned functions that are better, that are more appropriate for other individuals, and there are mental health calls that are better, that are more appropriate to be responded to by mental health professionals. While I was in the legislature, I sponsored what would have been the Stefan Watts Act, named after a young man who had a disability, and because there was a police response, there was a violent response to the occurrence that could have otherwise been de-escalated with more of a crisis intervention response. Yes, part of our consent decree calls upon the appropriate crisis intervention training of officers, but I think there need to be stair steps of approaches to such responses, whether a front team could be mental health professionals, because you're only going to train your rank and file officer so much to be able to respond to somebody with a disability, as opposed to somebody who's committed their profession, their life to dealing with those types of circumstances. Notwithstanding that, I am in favor, and not only with regards to Chicago Police Department, I think statewide, law enforcement officers need to undergo crisis intervention training and de-escalation training, so that situations that could be averted are.
Thank you so much for your perspective on this. Tons of questions have been coming in, and I am going to attempt to combine a few of them. We've received several questions about qualified immunity, and whether you see your role as changing in terms of, if you see your role as potentially reshaping the use of qualified immunity or supporting, calls to abolish qualified immunity. Kwame Raoul, Attorney General Raoul, if you don't mind addressing that big elephant in the room when it comes to addressing police misconduct.
It is a big elephant in the room, and I think it's something that needs to be examined. I spoke earlier in our conversation about licensing, about the need for more robust either decertification or accountability if it's a licensing system. That is driven by the reality that not only are our local department disciplinary processes deficient, but I mentioned earlier, under our certification system within the state of Illinois, you can only decertify upon conviction on certain offenses. Well, that conviction is very difficult to achieve, in part because of qualified immunity. And so we need to really thoroughly examine the use of qualified immunity, such that the rogue cop that is really violating the law, yet hiding under this umbrella of qualified immunity, that somehow they were acting in their function as a law enforcement officer. I don't think that is what policymakers want to provide, a protection for criminal acts in the name of the state.
Attorney General Grewal, do you have any additional thoughts to share on qualified immunity? Do you support eliminating it or changing it?
Yeah, I support looking at it anew and seeing if the balance that qualified immunity tries to strike is the right balance, or if there's places where we need to rethink how we use qualified immunity. In addition to the state's chief law enforcement officer, I'm the state's chief legal officer, and we do invoke qualified immunity in cases where we're defending agencies of the state. And as I mentioned earlier when I was asked this question last month, everything's on the table. And so we need to do a deep dive and look at the cases where we've invoked it and how we use it as a tool, and whether we should continue to use it as a tool. But that's an ongoing review, and it's not something that we've come out with a firm position on at this point.
Attorney General Grewal, what is the current role of civilian review in police misconduct in your state? And do you think that role needs to be re-examined or changed in any way?
Yeah, so I think, I've said this in other contexts and other forums. I think a robust internal affairs process is the best way to ensure law enforcement accountability. But I do understand that there are jurisdictions in my state where people don't have confidence in the IA process and the IA system, whether it's because of historical issues or because of the way a particular department has handled the IA process, in which case I do think that perhaps for those localities that a civilian review board might be the way to go. For years in the state, the internal affairs guidelines that were established by my predecessors did not allow for the sharing of law enforcement personnel information or IA files with the Civilian Review Board. We put forward a process in our most recent revisions to our internal affairs guidelines where that information can be shared with the Civilian Review Board. But my concerns there are that you got to invest in the Civilian Review Board. You need to train the Civilian Review Board up. You've got to make sure that you have the right people on the Civilian Review Board, and that they have all the resources they need to do that role effectively. And so, and there are a couple of other issues I have with, whether they should have subpoena power or whether those investigations should come after an internal affairs investigation or a criminal investigation, or whether they should be in parallel. So a couple of those issues are right now before our state Supreme Court. We don't have a municipality that has one in place, but Newark is trying to establish one. And so that issue on subpoenas and on the parallel investigations and on who should ultimately impose a discipline are squarely before our Supreme Court. So we'll get guidance from them as to how we move forward in this regard.
Attorney General Raoul, what does civilian review look like in Illinois?
Well, we did pass a independent review of police-involved shootings and certain misconduct. The challenge in the conversation around civilian review is some of what General Grewal talked about, is making certain the body that is charged with investigating such misconduct is competent to investigate such misconduct. And so what does that mean? That means in order to effectively investigate a scene where a misconduct or excessive use of force may have occurred, one must understand law enforcement pretty comprehensively, must understand how to investigate an occurrence. And it's not something that is easy for a layperson to do. Notwithstanding that, I think that we can move towards some sort of a hybrid process that allows for civilian engagement, and the critical thing in these investigations is that they be independent investigations, such that notwithstanding the fact that there will be internal affairs investigations at the departmental setting to investigate allegations of misconduct, there needs to be something independent upon that, instead of a review board relying on the either internal affairs or some other departmental investigation of an occurrence.
I was wondering, Attorney General Raoul, if you could tell us how your personal experiences with the police have shaped your work as Attorney General, as a state legislator.
Yeah, wow. I've spoken a lot about this over the course of the last month in a way that I had never in my life done before. And I don't know specifically what it was about the occurrence in Minneapolis, but it had me doing a lot of personal unpacking of personal experience I've had or experiences my son has had as a Black man, or dialing it back to Black boy experiences you have as a Black boy. You have conversations. I've had the conversation with my son. I've had the conversation with my stepson about how to come home alive from an interaction with law enforcement. It's a sad conversation to have. I responded to a social media post maybe about a month or a few weeks ago about how old were you the first time a police officer pulled a gun on you? And my answer was 17. And mind you, there's a lot packed into that question. How old were you the first time a police officer pulled a gun on you? And if somebody had asked the follow-up question, how old were you the second time a police officer had pulled a gun on you, I would have been able to answer that question, and I would have been able to say I was 19, 20 years old at that time, driving a brand new car that my mother had, and being stopped because I fit the description of somebody that had been committing auto thefts. And I put out there a question to some, how many times have you fit the description? And so these are the conversations that are being had, that are common conversations. And the fact that so many people have been able to respond to these questions, so many people who have never been arrested or charged with a crime. You know, I've never been arrested or charged with a crime, yet I've had multiple negative experiences with law enforcement. And you know, my son unfortunately has as well, and he's a sweetheart of a kid, who in one instance, when there was a shooting outside of our home, he was trying to seek to get back into his home and was being denied access and was threatened with arrest for obstruction of justice simply for trying to get into the safety of his home. And when I tried to put him on the phone with the commander, because I was not home at the time, he was afraid to speak to the commander that his father had connected him to because of his experience with law enforcement. And that said so much to me about the need to address law enforcement reform comprehensively, because I did not grow up a disadvantaged child, nor has my son. And so if we've had these experiences, think about the experiences that the Black boys who have grown up without a father, who've grown up in disadvantaged areas, who have had more contact with law enforcement, what are their experiences? And so it has definitely fueled my energy to try to do something on law enforcement reform.
Well, our time is running short, and I think we have time for one additional question. This is going to turn back to something that Attorney General Grewal spoke about earlier, and it's for either of you or both of you. Police unions are generally the most ardent opponents of any kind of police reform. What tools do state AGs and outside organizations have to circumvent the roadblocks to reform, like lopsided union contracts, that keep a lot of the accountability and transparency from coming to the general knowledge of the public?
I'll just jump in. One of the benefits that I have, I do consider it a benefit that other AGs don't have, is that I'm appointed and I'm confirmed by our state Senate, and I'm constitutionally independent, and I don't have to run for re-election or election. So I don't have to, worry about soliciting the support of the unions. I have the extraordinary luxury of doing the right thing for the right reasons, regardless of what the political calculation might be. And, really, I think in this moment, what Kwame just said was just so profound. This is the moment we are in right now. It's a moral moment, and it's a historical moment. And so I'm not going to let the union stand in the way of me pushing forward meaningful change. The experience that Kwame just shared, the people who are on the other side of that union table, when I talk to them about policies, will never know that. They will never know that. I will never know that. I will never know what it feels like to be a Black man in America or a Black child in America. I might like to think that I've experienced discrimination, and I have. It was my motivation to get into public service after September 11th, to come into public service to make a change in whatever position I have held, whether it's a federal prosecutor or whether it's a county prosecutor, state prosecutor, or now AG. That's why I'm here. And so I think what we have to do now is continue pushing forward, and you know, it's going to be a battle against the unions on many of these issues. On transparency, on some they see eye to eye with me, but we just continue to push because that's what this moment requires of us.
Well, our hour is up, and this has been an incredible discussion. Thank you so much to Attorney General Grewal and Attorney General Raoul for joining us today. I'd like to turn this back over to ACS President Russ Feingold for some concluding remarks.
Thank you so much. This was a great program, and Valerie, you did an outstanding job of moderating this. I just think how lucky the people of Illinois and New Jersey are to have attorneys general like the two of you. So capable and so tuned in to the needs of the people of your state. And you really illustrate the necessity of broad authority to stand up for the rule of law in this current context. You're showing real leadership, and it follows on our good luck in having Attorney General Keith Ellison of Minnesota help us with our virtual national convention. It's quite a group of leaders across the country. You show that the levers of the law have to work at all levels, particularly when one level isn't working so well. Obviously, I'm talking about the federal level. There are other levers that are critical and that are particularly valuable. And I also want to finally say I appreciate the specific conversations about issues like licensing and qualified immunity, which, you know, a lot of people don't know about. They know about the problems, they know about the tension in our country, but at some point, we need capable people like you to help us understand what exactly can be done and what makes sense. So we're grateful to you for your leadership and for your participation. And I'm grateful to the hundreds of people that joined us today. Thanks so much.